Okay, so we'll get past this in just a second here. This thing with Tom Cryer, for those who are expressing interest in that, Tom Cryer, the issue was about a fellow by the name of Clifford Kidd, who was facing a tax case, federal tax case in Austin, Texas. And I went there, and Clifford was convinced by a female to file some 1099 documents with IRS stuff against the judge. And I knew that it was going to be a problem, but he was convinced that, that she was on the right track, and he filed that stuff. And immediately they wanted to withdraw his bond and put him in jail, so that he would spend time in jail the whole time pre-trial. And they set a hearing for that. And I went. I was there with Clifford, see, and Tom Cryer was not. And Tom Cryer thinks that I created that problem when I did not, because I don't do that stuff. I know what it is. If this guy goes ahead and files that stuff against the judge is going to crack the whip on him. And that's exactly what happened. And Tom Cryer had even put it, if I recall correctly, 2 documents. And, one was mine, but the other one was not. And my document was simply my entry into the case so that I could help help Clifford Kidd. And anyway, my contention on that whole deal is that I did help Clifford Kidd because he didn't go to jail at that time. I told him that all he had to do was say to the judge, I made a mistake, I'm sorry I filed that stuff, and I withdraw it from the record. And it would be gone. And sure enough, that's what happened in the end at that hearing. But the judge was still upset and wanted him to have an attorney. Like I say, the problem documents were not, I didn't create them and had nothing to do with them. All I told him is that if you just withdraw those documents, you won't go to jail. And sure enough, when he withdrew that document, those IRS documents, he did not go to jail. But the judge told him that standard operating procedure, told him that he needed an attorney. So he went back to Cryer. And the bottom line on that is, Clifford Kidd was convicted. Okay? Now, which Cryer lays out as a success. It's kind of funny to me. I think that success is when you're not convicted. So he says that it was house arrest, but whatever kind of arrest you're under, it's not only that, but the conviction is a problem for anybody to get a felony conviction. Is there anyone here who doesn't understand what I'm talking about? When you get a felony conviction, you got a big problem. I know one woman that is like an angel, and she managed to get herself a conviction. They said that they were going to drop it down to a misdemeanor, but they left it on the record somehow as a felony. And she got herself a good job with the Target Distribution Center. And she started work there already, and then they said, no, you got a felony on your record, you're out of here. So she lost her job in a flash, just because of what was on her record, even though the woman herself is like an angel and wasn't guilty of the thing in the first place. But it's easy enough to get tagged with a felony, and the cops have these computers in their cruiser cars, and they get behind you at a red light, and just for fun, they run the plate and they see who you are, and then once they see that you got a felony on your record, and they'll shake you down, and they'll want to see if you got drugs, or you're drinking, or you this, or you that. It's the guys who got felonies on their records go through constant harassment with the police. It's just the way it is. So, anyway, that's Crier, and that's enough of that nonsense. One of the things I was going to share with you, trying to get off of this thing, but Barefoot Sanders, in that case with the State Department, and by the way, that case number is, for those who wanted to look it up, the case number for the case itself remains. That case remains in the law books. The citation in the United States Code Annotated, that's gone because Congress changed the law. But the case itself is U.S. versus Fox, 766 F Sup 569.
Say that again?
766 F Sup 569. Now, we're at a, now that I mentioned that, I'm going to share something else with you all. Does everyone here know how to use the law library?
No.
Okay. Would you like to know in just like 2-3 minutes flat?
Yes.
Okay. It is so simple and so logical, it's just incredible.
You go through the front door.
Okay, my case is this citation, okay? 766 F Sup 569. Now, this is like a code, okay? And this number here is the volume of the book. This is, how should we say, the category, and this is the page. So you go into the law library and you say, where's the F Sup? You say, well, it's over there. And so you go to this gigantic rack of books and you look for book number 766, and it's right on the spine, 766. And these numbers go up to 999, and then they start over. Okay?
Then you go to soup line.
So 766 in the F Sup rack, and you get this book in your hands, you open it to page 569, and there it is. Now I have other stuff like, okay, well, I should give you a real good one here. Now this one says U.S., and this means United States Supreme Court. Okay? If you go to this book, number 407, U.S., and look at page 25, you're going to see a case called Argersinger versus Hamlin. And so on and so forth.
Very
Now,
important case.
Yeah, Mr. Heitman knows that's an important case. And you can win, regardless of your circumstances in the court system, you can win with this one if you know what you're doing. I mentioned to you at the beginning that the good news is you can win on all these categories, and one of them I said is on the counsel issue alone. Didn't I say that? Okay. Well,
What case is that?
I'm winning on the counsel issue alone. This site is a case called Argersinger versus Hamlin, 407 U.S. 25. Okay?
Arthur what?
Argersinger, A-R-G-E-R-S-I-N-G-E-R versus Hamlin, H-A-M-L-I-N, I think it is. I will provide you the site on that stuff too. Okay? And so what that case says is no accused, that's y'all, no accused may be deprived of his liberty as the result of any criminal prosecution, whether felony or misdemeanor, in which he was denied assistance of counsel. And people will say, well, they brought me into court and right away they wanted to give me an attorney. Right? Well, what you need to do is thank him, but you need to interview the attorney for competence. Now, when you interview the attorney for competence, you're going to find that he's not competent. So it goes like this. When they bring you in and the judge says, well, I'm going to assign you this attorney here, blah, blah. Oh, thank you, Judge. Thank you so much. I was really worried, but you're helping me here, and I really appreciate it. However, I do need to interview this attorney to make sure he's competent. Now, on this topic, let's say this. I have a friend in Los Angeles named Ron, and he's currently facing a tax issue, and the court assigned him an attorney. And so Ron questioned his attorney as to his success, which is, of course, one of the questions you want to know. And the attorney's response was that 20 years ago, he helped one guy get a lesser sentence. Now, doesn't that really excite you if you're facing a serious prison time? 20 years ago, he helped one guy get a lesser sentence. I mean, is that a whiz bang or what? So if you ask, and I've got a set of questions, like 200 questions, and those of you who have emails and the rest of that, I can get that to you pretty quick and easy. And we need to probably make notes of this stuff too.
Pass around the list for email.
Well, you know what? We can do this.
Susie?
I think Susie has.
Susie's got it. Susie's got it.
Okay. Because if I have your name, your phone number, your email, and your snail mail U.S. postal designation, I can keep in contact with you and send you stuff. Okay?
Yeah, we need that.
All right. We're on the same team. Is that agreed?
Yeah.
Okay. So, I want to help you all as much as I can. I've got several sets of questions, but one is like 200 questions long. The bottom line is there's no attorney's going to pass muster on this stuff. So you come back in the courtroom and you say, Judge, I really thank you for having your kind consideration. However, this guy's incompetent. And the judge is going to say, well, we got this other guy here. He's real good. He's real good. And you say, well, I'd like to, I need to interview him first because my life is at stake here. The judge says, okay, well, go use the jury room there and interview him. So you go off there and you interview the guy. And he's as goofy and as competent as the other one. They're all attorneys. And so then you come back and you say, well, Judge, I really appreciate your kind consideration, but this guy's incompetent. Well, it's possible it could go to 3 attorneys, but I've never seen that happen. Okay? Typically at the end of 2, it's finished. And by that I mean the judge is going to flip right out. And he's going to say, there's no attorney in the whole state that's going to satisfy you, so you're just going to have to represent yourself. And that's that. Okay? Now, when he does that, what happened? They lost the case.
Do you think judges know about this?
Okay? They know, but they think that you don't. So keep your mouth shut about it.
Well, don't talk too loud here.
Well, I get amazed that how stupid these guys can get, because I could show you this. I got this right here. This, you can't see it, of course, it's just printing here. But somebody might want to look at it. And what this is the Ferguson case, 2 pages, the first 2 pages. And I notified the judge in Tim and Don's case about this thing here. And when he went off on me, when I raised the issue of religious objection to the oath, I mean, I couldn't believe that the guy was so stupid, you know? But then this is a judge who right behind him has got a portrait of himself in the courtroom, a portrait of himself, 4 feet tall and 2.5 feet wide. The only people I know of that's got these gigantic portraits behind them are people who are really, really convinced that they are something out of this world. Adolf Hitler, Mussolini, Mao Zedong, Saddam Hussein, you know. you get the picture. So, I mean, I couldn't believe a guy could be so dumb as to not know. I mean, this is from the 5th Circuit. This is his bosses. He didn't read their thing. He didn't read my stuff in the civil case that I warned him about this. And the whole thing's blowing up in his face because he denied me, my right to testify and Tim's right to have me as a witness. The guy's an idiot. Well, and especially the fact that they don't understand that what religious freedom means. See, I mentioned it to you right at the beginning that there are some powerful tools, and religious freedom is one of them. And I've got a list here that I just threw together in the jail cell. Okay? Now, one of the things was, went to Dallas County Jail, and they served breakfast, and I didn't touch the tray. And the guard came to pick up the empty trays, and he sees that I haven't touched the food. He says, "What's the problem?" And I said, "Well, I don't eat pork because it's against the Levitical food laws." And he said, "Well, that's not pork." I said, "Well, what is it?" He said, "That's ground turkey." I said, "Are you sure?" He said, "Absolutely." He said, "The Muslims have sued us so much that there is no pork in the kitchen whatsoever. None."
Only pigs. Only pigs.
Huh?
Only pigs.
So, this one guy, Jeff Skiba, I'd already had this experience on the oath issue in the Skiba case. I'll come back to that. But because we're talking about the religious freedom, I'm just going to give you a couple other points here. And one of the real whoppers is this one here, Gonzalez v. O Centro Espirita Beneficient Unia do Vegetal. And anyway, what this is a case. U.S. Customs had some 5 barrels, and I guess these are like 55-gallon drums on the dock. I think it was probably Los Angeles or something. These barrels had come, barrels of tea from Brazil, destined for a Brazilian Indian tribe church in Arizona. So maybe you all have heard of it. So one of these customs officials takes it upon himself to check what this tea is. And it's like the powder stuff, like you got in the tea bag or something. But this is no ordinary tea. They check and they find it's Schedule 1. Now, do you know what Schedule 1 is? Stuff like heroin, cocaine, methamphetamines, those are Schedule 1. Okay? So 5 barrels of this stuff, and they go bonkers because they check. I and they find out that there's been 15 previous shipments. You know? And so that brings the Department of Justice attack on this church in Arizona. And the whole works goes all the way up to the Supreme Court of the United States. And the Supreme Court said to the Department of Justice, there was a time when something could be done about this. However, now that Congress has passed the Religious Freedom Restoration Act, you can forget it. Give them their tea back.
That's a happy church.
It's a happy church. Well, I heard this last item here, something that's interesting. And I cite this in all of my stuff in this first paragraph on an affidavit. And what it is Federal Public Law 97-280, 96-1211. You don't need to worry about writing it down because I'm going to provide you with the affidavit and you'll see it in there, in the first paragraph. Now, what that law is it's something special. And what's special about it is this, that this law is the only law that has ever passed through Congress unanimously. Even the declaration of war against Japan after Pearl Harbor did not pass unanimously. This is the only one that ever did. And what this law says is that the Bible is the Word of God, and that we should apply its teachings in our lives. It goes on to say a bunch of other stuff, but that's the serious part. It's the only law that ever passed through Congress unanimously. Declares that the Bible is the Word of God, and we should apply its teachings in our lives. And I use that continually. Why do you think that I'm still here? Immigration would have deported me. You know what I mean? And so,
King James Version.
huh?
You should say the King James Version.
Well, understand that that's commonly accepted. And I got the King James Version right here, but there are some others that are very good too.
No, they all misrepresent the truth. Don't argue with him. He's right on me.
Well, you can use the right cover. What's inside doesn't matter, right?
You got the right Bible.
You know what it is telling you this. He tells you the message with stammering lips, etc. And what it is that you have to pray for wisdom when you read that book because the stuff is hidden from you. I'll give you for instance. I don't know how many people here understand that, like, number one, the Bible doesn't waste words. And it says that David selected 5 smooth stones from the brook. Now, why was it 5 instead of 3 or 15?
Why?
Goliath had 4 brothers. They're named elsewhere in the scriptures. So if you think about that one for a second, from David's perspective, like a chess player, from his perspective, he's going up against Goliath. Goliath has 4 brothers, and when he kills Goliath, the 4 brothers are going to be on him. So how many stones is it going to take with our Heavenly Father guiding his aim? 5. 1 for Goliath and 4 for the brothers. Not 6, not 7. No misses.
You like that's all you could count.
That's all he could count. He forgot about his other hand. Okay, so, all right. This thing here, by the way, all of these different categories, there'll be like, there'll be this one here, there's F, F2D, F3D. If you can imagine this, you go to this law library And this F sub stands for the federal trial court. Their appellate court is just F, okay? But this is the first series. Then it goes to the second series, F2D. Then it goes to the third series, F3D. Like I mentioned, the spine of the book goes from 1 to 999. Basically 1,000 books in each set. So in this stuff, you're looking at, they're working on their third 1,000. And so there's a lot of stuff there. But this kind of an arrangement where this is the volume, this is the set of books, and this is the page number, you can find anything in a flash in that law library. And so you don't need to be scared of it at all. How's that for a quick, short law library visit? Okay, so on the council issue again, that Argersinger versus Hamlin, if you get them on that, they're toast. They did this. I'll explain this case to you, and this is kind of interesting. I think anyway. You tell me if you don't think so. So there's this guy, Don McCarley. This is a true story. So Don McCarley is a trucker, and he stops to use the phone at his brother's office, a high-rise office tower on the North Dallas Loop. Okay? So he's there on the phone, and that day, surprise, surprise, 9 IRS agents arrive with their badges and guns, and it's search and seizure time, folks. And they come up to him, and they grab the phone from him and slam it down, and they say, "Who are you?" And he says, "Am I under arrest?" And they said, "No." He said, "Well, fabulous." And he goes, "I'm out of here." And he gets up and he goes out to the hallway, and he's going down the hall, and suddenly he remembers he forgot his car keys on the desk. He half turns around. They tackle him to the floor, beat him up, handcuff him, and haul him off to jail. And charge him with 2 charges. One is assaulting federal officers, and the other one is impairing a search and seizure. Well, he doesn't have the money for an attorney. And I'm not an attorney, but, sometimes I do some typing. So what happens is, I typed the thing up, and it says, these IRS agents that say that they were assaulted. And by the way, you have to get how preposterous this is. Because meek, mild, polite Don McCarley, who is so nice to everybody, unarmed, is going to attack 9 armed IRS agents. How ridiculous can you get? It's so preposterous that, any logical person is going to say, that's ridiculous. But it gets better, because I put in the document, I said, okay, these IRS agents claim that Don McCarley assaulted federal officers, and they're the federal officers that he assaulted. Only problem is, IRS agents are not a part of the government, therefore they're not federal officers, and their claim that they are is a 10-year felony.
Oh, wow.
And that charge disappeared from the planet. There was no discussion. There wasn't a hearing. There was no talking about it. There was no paperwork. There was no response. That charge was disappeared from the planet, and that was the end of that charge. Gone. Now, Don McCarley comes into court, and federal judge Jerry Buckmeyer is there, and Jerry Buckmeyer knows me because he's the guy who signed the order to send me to Springfield on the oath issue. And while I was at Springfield getting my head examined, while I was there getting my head examined about the oath issue, the Fifth Circuit Court of Appeals, his bosses, ruled in my favor in the Betty Ann Ferguson case. You know, and anyway, Jerry Buckmeyer's there. Don McCarley he informs Jerry Buckmeyer that he wants Robert Fox as his assistant of counsel. And Jerry Buckmeyer says, no, Mr. Fox is not a licensed attorney in the state of Texas, and the answer to that is no, and no is no, and that's it. There's no way. Okay? So, what did he do? He denied Don McCarley assistance of counsel. And he wanted to force him to go to trial on his own 2 feet. And that's what happened. Don McCarley went to trial on his own 2 feet, doing the best he could. And he didn't have assistance of counsel. Jerry Buckmeyer denied that. And so these IRS agents, they said that Don McCarley beat him up. They didn't claim to be federal officers anymore, though. They just said that Don McCarley beat them up and damaged their wristwatch and bent their eyeglasses. Oh, it was just terrible. So they went on to say that the way he impaired the search and seizure, which was another puzzling thing, because how does Don McCarley impair the search and seizure when he's in the hallway and the search and seizure's in the office? Well, you're going to love this one. So they talked about it, and it was the prosecutor that really helped the jury to understand how Don McCarley impaired the search and seizure. Now, the way the trial goes, by the way, for those who don't know, the newbies, the government goes first, they present their witnesses and evidence. You got the prima facie break, then the defense presents their witnesses and evidence. Then it goes to closing arguments. The government goes first, then the defendant goes next, and the government gets another shot at it with no possibility of rebuttal from the defense. Okay? It's a setup, you know, so that the government gets the last word. They get the first word, they get the last word. That's why their win ratio nationwide is less than 2% for our side. You know, when the cops say you did something, you're almost a goner right there, unless you study alternative stuff like this. You know, and what I'm describing to you in this counsel issue is one that you could potentially win with even if you were guilty 10 times over. So they said, the prosecutor says, well, the way he impaired the search and seizure was that it took 3 officers to take him to jail, and they came with 9, and they only had 6 left to do the work. Now, I wrote up the thing for his allocution and pointed out that following that logic, they could have stopped at the Galleria Mall, selected 3 random shoppers, put 3 officers on each one, taken them to jail, and boy, the search and seizure would have been really impaired because there would have been nobody to do it. You can't tell us what happened after you put the handcuffs on him. You got to tell us what happened before you put the handcuffs on him. Right? And was he impairing the search and seizure before the handcuffs? No, he was in the hallway. So anyway, Don McCarley comes in for sentencing because the jury convicted him. They listened to this crap and went ahead and convicted the poor guy. And so, you know, I mean, he was devastated. And I said, well, it's not over yet because you got sentencing, and at sentencing, the judge has to ask a question. And the answer, if you know what to give the right answer, you walk out the front door. I'm not kidding. I'm not kidding. There's Do you remember Robert Bork?
Yeah.
Okay, he was Solicitor General for the United States. If somebody sued the United States, that lawsuit landed on his desk. So, he was Solicitor General for the United States. They were considering him for Supreme Court Justice. He didn't make it, but he wrote a book called The Tempting of America. In the first edition only, because after that it's deleted, he made the statement that everyone who is in prison in America today is there voluntarily. Voluntarily. And the place where you volunteer in their criminal process is at sentencing. And the rule on that is the Federal Rule 32, which is to do with sentencing. And there's a whole bunch of stuff in that rule, but there's a paragraph in there that says the court shall, and shall means must, the court shall address the defendant personally. You may have an attorney, you may have like the dream team, like OJ, but that doesn't count. The judge addresses the defendant personally, eyeball to eyeball with the defendant, and the court is required by the rule to inquire whether the defendant has a statement to make or any information in mitigation of sentence. Well, now isn't that interesting? Let me ask you, since they've already got the jury conviction or bench trial judge conviction, they've got the cells waiting, they've got all the guns, they've got immense manpower, and they have to ask a question. The reason they have to ask a question is because it's your turn to volunteer. So if you give them the wrong answer, you go to prison. And in Don McCarley's case, we've done it up in writing with an allocution affidavit. And that is helpful, but it's not the be-all and end-all. The real stuff, the real deal is what you speak in the courtroom. Like I mentioned, affidavits are hearsay until they're testified to. So when Don McCarley speaks it, that's what really does it, as testimony. So Don McCarley's allocution, the number one was the fact that he'd been denied assistance of counsel. He requested me, was denied, and the United States Supreme Court said that they can't incarcerate him on that basis. How do you like that? Then the other parts went on, like how do they possibly claim that Don McCarley assaulted or impaired the search and seizure, because the assault thing was gone. How he impaired the search and seizure on the basis of them talking about what happened after they put the handcuffs on. And there was a whole bunch more stuff in there. And, that the judge isn't an Article 3 judge, and that the court isn't right, and so on and so forth. And so anyway, the Argersinger versus Hamlin and the other stuff carried the day, and Don McCarley walked right out the front door of the federal courthouse in Dallas, had his sentencing. Now, before that happened, of course, he's in court, and you'll get a kick out of this, I think. Knowing what they're like, I did up a script for Don just in case the assistant U.S. attorney tried to speak at his allocution. And sure enough, that's what happened. Don McCarley started up, and immediately the assistant U.S. attorney jumps up to object. So Don McCarley turns on him and says, This is my elocution, and I deny that any pettifogger, shyster, groveling for filthy lucre has the status, standing, and authority to speak at my elocution. And that guy went beat red, sat down, had not another word to say. There wasn't a peep out of the federal judge.
Say that again.
Can you repeat the question?
Are you serious?
Yeah, I need to hear it.
You're putting me on. Okay, you want to hear it again? Serious?
Yeah.
Okay, Don McCarley said to him, when he jumped up to make an objection, Don McCarley said, this is my elocution, and I deny that any pettifogger, shyster, groveling for filthy lucre has the status, standing, and authority to speak at my elocution. The elocution is the judge asks him a question, and he makes the answer. The prosecution's got no space in there, you get it? No space, they got no room to talk.
The
It's
objection
between him and the judge.
Can you just say, shut up?
Sounds good.
It's not as good as what I put together.
You need to have a mouth full of words on that one. Juicy. Juicy.
So, goes to show you can still have some fun. And, but they didn't think it was fun for the systemites. And Jerry Buckmeyer actually tried hard to get Don McCarley just to shut up and go away, you know. But Don McCarley had to get the stuff off his chest because he was really upset about the whole situation. And so he laid it on him thick and heavy and walked out the front door.
And what do? They just let him walk out? I mean,
Yeah.
That's it? After he speaks, he says, you're free to go.
The judge let him go.
Didn't volunteer.
Didn't volunteer. Exactly. And so if you're ever faced with that situation, and we'll go over it tomorrow, we'll go over it, you know, the steps in the process. You get to that position, do not volunteer or consent to any of it. You know, because they're going to say, well, we want to, you know, sentence you to such and such. Say, well, excuse me, what's the sentence for someone who's innocent? Well, you're not innocent, you were found guilty. No, you guys framed me with your nonsense. You denied me my witness, you know, like Tim and Don. You know, the judge denied me when they asked me to be their witness. I was flanked by 5 U.S. Marshals and basically booted out. Okay? That's against the law. You know, how this judge ever thought he could get away with that nonsense is beyond me, but, you know, the guy's an idiot. You know, he's so infatuated with his big portrait behind him. You know,
He's watching himself.
yeah, he's so busy with watching himself that, you know, that he doesn't have time to read my documents. Otherwise, he would have known that he was being forewarned as to the possibilities.
But they do break the law and they get away with it. And the reason they get away with it is because we don't know what to do. Am I correct?
Yep. Yep. And this gentleman brought up about, he said, we don't know what to do. And he said that earlier in private that he'd done some affidavits and that nothing happened. And of course, I don't know exactly how or why in your particular case. Affidavits work for me, and if they don't work for people, I'm not exactly sure why, but you can run into bozo idiots like this judge in Tim and Don's case, or Jerry Buckmeyer, who just openly told Don McCarley that he couldn't have me as assistants of counsel. You know, and of course since then, you know, I mean, I've sat at the defense table in 5 different states in federal court. In Texas, by the way, the judge had 3 of us, not just me, but Richard Taylor and another guy, but if the name's on the tip of my tongue, it'll come to me. But because he's a real good guy too. So there were 3 of us at the defense table helping Kenny O'Kane. And unfortunately, Kenny had left the whole thing to the last minute, working around the clock. And he was so exhausted he couldn't function. I prepared a set of questions for him, he couldn't even read them.
Excuse me, did you say you were going to provide us with a copy of the affidavit?
Yes,
Okay.
yes,
With that statement?
you're right.
I can tell you why that is.
Pardon me?
I can tell you why that is.
Okay.
You want- Yeah,
You want-
speaker.
Yeah, but keep it short.
I was at a hearing, and I had 3 witnesses sitting back here.
Take your hand off the mic.
3 witnesses sitting back here. They were going to testify the affidavits they put in. This judge says to me, I would have known better, but I didn't. I thought I'd cite it. So I figured I was going to win this case no matter what. Well, he says, Mr. Hyman, well, he says, this is going to take a long time. He says, why don't we just agree? And I'm sure Mr. Erickson, the other attorney, will agree that we'll just put them on the record and they will be as if they were testified to, ready in the record. And it's going to save us a whole lot of time because we'll be here most of the day if we don't do that. And he says, won't you agree, Mr. Erickson? Yeah, I agree. I guess he would. And as soon as I said, yeah, I tried. You know why?
Because they would testify
One of
to.
those testimony, one of those affidavits had, you have 30 days or so many days in which to answer or deny this. And if they didn't do that, then they must testify to the affidavit or the affidavit's worthless. And I walked out there, this same judge took the files to his office 130 miles away to Pocatello Island and kept them 6 weeks. And a lot of the stuff that was on the record is not there anymore. So what I'm telling you is the affidavit has to be testified to unless it has the language in it that he put in there. Otherwise, you're fried. There was one other thing that you mentioned there just a minute ago. I forgot what it is. That's the most important thing I had to say, but there was something else that was in my mind. I can't remember what it was because I'm overage.
So the affidavits that I'm doing, like he was saying, it's taken some time to put that stuff together, and I haven't had anybody challenge me on that stuff. And to me it means that it's working. If you're going to use something, you're welcome to copy it. You have your own case and the particularities of your own case. But the framework of the affidavit with this paragraph and the way it ends, those 2 pieces are, to my way of thinking, they're a proven element from this. But if you deviate outside that, it's at your own peril. I've had people that would delete that whole last paragraph. Now, I don't think that's a smart thing to do because you could easily fall into a trap with them, and they could say you made a falsification here, and they put you in prison.
The other thing I had in my mind was this business of allocution. There's a case, I can't remember the name of the case, but I think you can find it if you search it right. It was a Florida case, and this old black woman had a son that used to deal in junk. And he walked home, and they searched the house, and they found the narcotics, and they charged her with it. And she didn't know what she was going to do because she wasn't ever involved in the narcotics. You know, she was a kid, but she didn't know what to do. So it came up to allocution. I read this case myself, and I forgot the name. I read this case, and it's a Florida case. And she went to sleep there, went to bed that night, and she all of a sudden woke up in the middle of the night and she had this dream. I'm not going to take that sentence. So she goes to court the next day and they go through a whole business. Well, Mrs. Smith, whatever, man, I'm going to give you 25 years in prison. Do you understand me? She says, no, I don't understand. I'm not taking that sentence. Oh, we got to have a sidebar so they go up there and have a little talk. And they come back and the attorney walks over, would you take 12 years? And she says, no, I'm not taking no sentence. I am not taking this. I'm not going to jail for something I didn't do. I'm not accepting that sentence. When you say you're not accepting that sentence, they've got to pound you in the head with a club until you do accept it. And she kept that up, and they went down, well, would you go for 6 months? And towards the end. And she says, I am not accepting no prison sentence, but I am not a criminal. I'm not taking that sentence. Guess what? She walked out the front door. And I don't know why I can't remember, but I got a lot of other things on my mind too. So that verifies what he said. I remember that case very, very well because I used it myself. The same thing in a case last January. They found a decision, and it was just a railroad job. The attorney and the judge and myself. And the attorney testified. The attorney cannot testify for summary judgment, period, because it has to be a live client. And I said, I'm not taking that sentence. I object, and I've done so within 3 days on the Magnuson lost our trade warranty. It's a contract they're offering you, and all you have to do is accept the contract.
Or not.
Yeah. That's the key point, is you do not accept anything that they have, and that's the end of it. And the whole system is voluntary, and it's not because I say so. And Robert Bork even put it in his book. And on the council issue, I thought of another one I should probably share with you. So I mentioned earlier, some buzzing here.
Rewinding the tape.
Yes, we rewind the tape.
Oh, okay. So I mentioned earlier John McGladdery. He had a friend, a lady by the name of Isabel Suarez, and her husband had been in a train wreck and damaged his head, so he was just good for like sweeping the floor in the warehouse. And they had a son. And Isabella was the breadwinner for the family. And she got accused of a felony in Chicago, and they had her in the news and the front page of the newspaper and all. She did like everyone does. She went ahead and hired herself a good attorney. And she took a whole box of evidence that proved that she was innocent. And this guy didn't look at any of it. And he postponed the case. It's called continuances. One continuance after another for a year. Getting close to trial, she took him a list of the witnesses to be subpoenaed because these witnesses could prove that she's innocent. He subpoenaed none of them. So, just days before the trial, he tells her that she needs to wrap up her stuff because come Monday she's going to trial and she's going to prison. Now, isn't that a great defense strategy? after she paid him, thousands of dollars, that's the defense strategy.
I just had a quick question. Concerning the allocution, if there's, say, the most perfect scenario where there was eyewitnesses to someone that murdered another person, would that allocution strategy still work? I mean, is it 100% completely voluntary? If there's
Well, it's,
No,
pardon
no.
me?
Because if it was a murder case, it's an offense, not a crime. It won't work in an offense. An offense is something against the human body. If you damage another human, it's in the Bible. You won't get off ever.
Okay.
There's no way. That's one of the reasons why you'll find in all of these processes, thing Gordon Hall does and this, et cetera, they won't work because those people that are in prison that have done those heinous things know they're wrong.
Is Gordon Hall here?
He left this morning.
He was here this morning?
Yes. He's with his land. It's on top.
We were talking about.
Flip the switch. We're gonna switch on the switch.
Hope I'm okay coming up here. We were talking about that because what happens if somebody killed your child? And the court system, that's the only justice system we have on the face of this earth right now. And just because some guy comes up here and says, I'm not going to prison, well, what then? I mean, as a parent, what does a parent do? Or a wife or whoever?
Carla, it would go back to something like I was trying to share with you all this morning. And that is that when I would try and help somebody and they could fool me, I'm gullible that way, I'm soft, okay? I know I've made me look like I'm rough and tumble, but, like a marshmallow. So anyway, and I used this line on an airline stewardess, not this last trip, but, I said to the airline stewardess, I said, landings are very, very scary. And I said, I'd feel a whole lot better if you'd sit and hold my hand. She says to me, nice try, but you don't look like anybody would be scared of anything.
That's great.
Anyway, I get tricked sometimes, and I do work for people that are actually guilty. But what happens is, they freeze up. They can't do it. And even if they could, Carla, something else will happen. I didn't mention this before, but two of the police that arrested me, I've been arrested over 30 times, but these two guys were together on one arrest. Both of them lost their jobs. Two other cops on separate arrests both died, and they died young. One of them was turned to mush on the 635 loop around Dallas while he was trying to issue a ticket to somebody else. Two judges were unelected. District Attorney Ray Summerall from Rockwall County, who framed me and put me in jail for half a year on bogus charges. And later I made myself dinner, I sit down, and I turn on the TV to catch the news. And surprise, surprise, Ray Summerall, flanked by two deputy sheriffs, coming out of the courtroom, sentenced to prison. Why? Because he tampered with evidence, coerced his employees to perjure themselves, falsified records, embezzled from the state, all of that. He ended up with 15 years in prison. Yeah, he put me away, but it got up to him.